With that January 1st deadline come and gone, still lots of litigation in various venues challenging the state's gun and magazine ban and registry. Welcome back. It's Bishop on Air. Like, subscribe, hit that notification bell. Support the program if you want with some merchandise below, at least on the YouTube link, or you can find me anywhere. Just go to bishoponair.com. bishoponair.com. All right, let's kind of hear some of the arguments that are being made in the latest litigation against the state's gun and magazine ban back in state court. And we chatted with Tom DeVore yesterday, shared that with you, and he was in court seeking to reinstate his cases where he had over 7,000 temporary restraining orders in place because of the state's gun and magazine ban through much of last year, if you recall. So he was back in Effingham County Court where he made the arguments that the judge should reinstate the case because the case was ultimately vacated after the Illinois Supreme Court in the separate Dan Calkins case. They ruled against Dan Calkins, but Calkins was looking at things on a facial challenge, DeVore says, versus an as-applied challenge. Now, a facial challenge just says, on its face, this law is unconstitutional. An as-applied challenge says, as this law has been applied, it's unconstitutional. Both may have been talking about in state court the equal protections arguments with that underlying theme of the Second Amendment being absolute, but the equal protections arguments where you've got some people carved out that they don't have to comply with it, other people do have to comply with it, even though they may be somewhat similarly situated, at least when it comes to training. So the training aspect here, saying that, police officers, retired police officers have certain levels of training, that, the National Guard members, they can use their firearms in the service of duty, security guards, prison wardens, they have training that is above and beyond what the typical person can get. That seems to be one argument, but it's not just the training aspect, it's also the classification. Somebody like a journalist is not a police officer. So they're play different roles. And that's really the answer I got from Attorney General Kwame Raoul when I asked him after the Illinois Supreme Court heard the case. This was before the ruling on the case, but I remember asking Attorney General Kwame Raoul whether or not somebody like me or anybody really that's not a law enforcement officer, could they get the same type of training that others can get?
Back to the question of training, can I not get the same type of training that law enforcement can get, or security or wardens can get? Can I
Well, you play a different role, right? It's not just a question of training. You're not in a law enforcement role, I don't think.
So again, Attorney General Kwame Raoul saying that it's about the role people play. Well, when we talked with DeVore earlier this week, he essentially responded to that directly.
And in our case, the state of Illinois, the lawyers argued over and over that these exempt categories have training, specialized training in the exempt banned weapons. It's not true. It was a lie when they said it in the courtroom. It's a lie as we sit here today. And so even if you're willing to follow the precedent from this one federal case out of Connecticut, says it has to be a person who has been publicly charged to protect the public, and they have specialized training, then and only then is there a facial issue on a facial complaint. But we're arguing, again, as applied, that says the training doesn't lie with these exempt categories because they don't have any training in the exempt categories. We've proven that, at least enough to get past a motion to dismiss. And we have people that have just as much training as these prison wardens, being conceal and carry training, which is an equivalent of what they have. And again, the court cannot dismiss our case without us being allowed to get into the facts that we want to get into, because we're not making a facial challenge. And that is reversible error for the circuit court to say your case is over, you can't never win, because we're not making a facial challenge. That distinction is significant.
So again, that's Thomas DeVore, who yesterday was in Effingham County Courts. I was going to connect with him yesterday afternoon, but I just got a ton of news that piled up on me, some of which we're going to be unpacking in future segments here today, so stay tuned for that. But I did reach out this morning to DeVore and asked what an update was, just the upshot, and whether or not not the judge took the case under advisement, and the judge took the case under advisement. So we will be watching that Effingham County case, in particular if the judge is going to reverse his decision to vacate that set of cases and actually go through and recognize it as separate and unique from what the Illinois Supreme Court heard. So a lot more to come on that in the near future, no question. But there's other things going on, of course. Next week, you've got the Illinois Supreme Court coming into session. But the week after that, you've got the Illinois General Assembly coming back into session with the Joint Committee on Administrative Rules set to meet on January 16th. Why is that significant? Well, the Joint Committee on Administrative Rules, they're that legislative oversight body that looks at how administrative rules get implemented. So when a bill passes the General Assembly, then the governor signs it. To execute the law, the executive branch then writes rules to execute the law. Then it goes back to the legislative branch as an oversight, the Joint Committee on Administrative Rules, and they review these administrative rules to make sure that they're in line with what the intent of the bill they passed was. So it's kind of a check and balance, right? So different, processes for the rules being filed, but the rules for the gun ban registry were on an emergency basis, and they were filed September 15th for the October 1st opening. And it spelled out a whole bunch of things, definitions of what a, quote, assault weapon is, and an attachment, and the different outlines for the electronic endorsement affidavit with the window closing January 1st. So you had that emergency set of rules filed. Well, now JCAR has a second notice rule filing in front of them that they didn't take up before the January 1st deadline, but they're expected to take up those second notice rules January 16th. But Madison County Record, they have a story here that I want to overview with you, and that is headlined, Oversight Committee Raises Questions About Assault Weapons ahead of Monday's registration deadline. And then it goes through and it talks about as the new year begins, Governor J.B. Pritzker's ban on so-called assault weapons takes effect under emergency rules. A lot of unanswered questions. The Joint Committee on Legislative Rules, JCAR, that's the Joint Committee on Administrative Rules, adopted emergency rules for Protecting Illinois Communities Act in September, but failed to adopt permanent rules or amend the emergency rules. Questions the committee asked State Police Director Brendan Kelly in November, and his answers capture their struggle to finish the job Pritzker and the legislature started. The committee's questions and Kelly's answers are listed below and condensed for clarity. So it just goes through a bunch of these different questions and how or if they're answered, right? I mean, for instance, let's say many gun clubs, security companies, and other organizations own items such subject to the affidavits. Typically, club presidents or local managers sign the firearms for them. Must an affidavit be updated when may change in leadership occurs? This issue may also impact collectors and museums. So you can see this, you really get into the minutia here, and it's important because, law-abiding gun owners want to be law-abiding. And when you have these really technical types of questions, does it allow for clear, definitive answers? Or does it just add to the confusion of all of this to where you've got people saying, listen, this is just unworkable. The Second Amendment says shall not be infringed, and these are all clearly infringements. So it goes on and lists all of these different questions. I would definitely encourage you to go check out the Madison County Record. Where you just search the headline, Oversight Committee Raised Questions About Assault Weapons Ban Ahead of Monday's Registration Deadline. So you can see the latest there. So clearly a lot more to come. Of course, the Calkins case, you've got the steps of the U.S. Supreme Court going into conference. That's going to be tomorrow. And they're actually asking them to, take up this case from the Illinois Supreme Court. So we'll see that if we get any kind of reports out tomorrow from the U.S. Supreme Court on their conference on that issue. But we've got all the mix of other cases as well, including the Fifth Amendment arguments in the Southern District of Illinois, which we've covered as well this week. With developments being the state must respond to the Fifth Amendment argument by January 19th, I think it was. But they have a January 12th date that they have to meet for a scheduling conference so they can start scheduling out when they're actually going to deal with the merits of this issue. So clearly a lot of big things going on. We will watch it all closely, and hopefully you'll be along for it as well here with Bishop on Air each and every weekday morning. All right, like, subscribe, hit that notification bell. Thank you so much for being here live to tape. All right, I'm doing all this switching and making things happen and, pulling up all kinds of stuff. So appreciate you guys letting me flex my talk show muscle each and every morning and giving me a healthy audience. So keep it up, all right? Stay tuned. We got plenty more. Just subscribe and hit that notification bell with Bishop on Air.